Hey guys, this week we have two lectures. We're going to be talking about fundamental American liberties and the struggle for equal rights. Your first exam is going to be February 7th, so it'll be just very similar to your first quiz, posted on Blackboard, same sort of thing, slightly longer. You'll have about the same amount of time to take it. If you have any questions, please email me, but it shouldn't post any challenges. That will be posted on February 7th, and you'll have a week to complete it. Today we are talking about fundamental American liberties, and the book starts out talking about regulating gun ownership. So, of course, in 2012, there was the Sandy Hook Elementary School shooting. I know you guys are all very familiar with school shootings and something that you live with all the time. After this elementary school shooting, President Obama was president at the time. He vowed to really outlaw assault weapons. He formed this task force on gun violence with Vice President at the time, Biden, leading it. He proposed that Congress pass legislation banning assault weapons, wanted universal background checks on gun purchases, etc. Former Congresswoman Gabby Giffords, she was shot in the head in a mass shooting. She formed Americans for Responsible Solutions. Former Mayor Michael Bloomberg formed Everytown for Gun Safety. All of these things, there were record donations to the Brady campaign to prevent gun violence. All of these things happened, but yet nothing happened. No congressional action was taken. Speaker Boehner, John Boehner was Speaker of the House at the time. I was actually working on Capitol Hill then. Made a floor speech. He expressed a lot of regret, but he could not promise action. The Senate compromised on a bill on the Senate had a compromised bill on background checks. Even that failed. It was a really tough time, and still is a really tough time to get things passed in D.C. When we founded this country, Patrick Henry had the message, "Give me liberty or give me death." Americans put a lot of stock in their freedom. Certainly they live in the least restrictive country in the world, but collectively we live in a government, which means we aren't free to do what we want. We have limits on our freedom that allow us to live peacefully with others instead of the chaos of everybody doing exactly what they want all the time. John Locke said, "Liberty doesn't equal license. The freedom to do some things does not mean the freedom to do everything." Deciding what rights we give up to join civilized society and what rights we retain is a great challenge of democratic government. Civil liberties and civil rights are different things. Civil liberties are the individual freedoms guaranteed to the people primarily by the Bill of Rights. Civil rights are citizenship rights guaranteed to the people primarily in the 13th, 14th, 15th, 19th, and 26th Amendments, and that are protected by the government. Civil liberties protect our right to think and act without government interference, the right to express ourselves and choose our own religion. Some are shakier. Do we have a right to privacy? What about civil rights? Civil rights are usually an extension of government action. It usually means that the government must treat all citizens equally and apply all laws fairly and not discriminate unjustly against certain groups of people. You distinguish between authoritarian government and non-authoritarian government. In that non-authoritarian government, including democracy, gives citizens the power to challenge a government if they believe they have been denied their basic rights. Democracies depend on the existence of rights. Civil liberties provide rules that keep government limited so it can't become too powerful. Civil rights help define who we the people are in a democracy and give those people the power necessary to put some controls on their government. We take a lot of our freedoms for granted. We speak confidently, of course, of our freedoms of speech and of the press, of our religion, of our right to bear arms, to our right to a fair trial, right to privacy, but none of these are inevitable. John Locke's writings during the Enlightenment brought about the first real discussions of rights at all. Nobody claimed rights against government. Instead, they thought that the government had all the power and only gave subjects privileges they were willing to bestow. John Locke said, "We had a right to life, liberty, and the pursuit of property, and these were conferred by nature, and government should preserve the natural rights of its citizens." This was central to the founding of the American government. Practically speaking, a government can do whatever they want as long as they remain in charge of the police and military. But public opinion is outraged at the invasion of individual rights. Unless a government is willing to dispense with its reputation as a democracy, it must respond in a way to pacify public opinion, which can be a powerful guardian of citizen liberties in a democracy. A person who can successfully claim that he or she has rights must be respected by a government, has rights that must be respected by a government, is a citizen of that government. A person who is under the authority of a government but cannot claim rights is merely a subject, bound by the laws without any power to challenge or change them. This doesn't mean that a citizen can always have things their way, nor does it mean that a non-citizen has no rights in a democracy, but citizens do have special protections and powers that allow them to stand up to the government and plead their cases when they believe an injustice is being done. So what about when rights conflict? Often for one person to get his way, another person must lose out. The first type of right conflict occurs between individuals. One person wants to pray with classmates. Another student doesn't want to be subjected to religious practice. The second way rights conflict is when the rights of individuals are pitted against the needs of society and the demands of a collective living. So the decision to wear a helmet or a seatbelt, this seems like an individual decision, but society has an interest in regulating these behaviors because jeopardizing one's safety is costly to society in terms of loss of talent, wasted public investment in a person, cost of medical care, etc. One of the most important aspects in claiming and defending rights is building and perpetuating a narrative that the right you claim exists and that you deserve to have it. They're often competing narratives. Women have rights to their own health without government interference versus the government must protect the rights of the unborn. What about guns are protected under the Constitution versus it's a privilege that the Constitution allows to be regulated? The NRA has really controlled the narrative about guns so strongly that any regulation at all is seen as a death knell to gun ownership, though every right we hold is regulated in some way. So what about when rights conflict in national security? After 9/11, Americans were really afraid. So government federalized airport security. They started screening passengers. They started searching luggage and allowing armed agents on planes. They kept a close eye on folks suspected of having ties to terrorism. The 2011 Patriot Act made it easier for law enforcement to do things like intercept email and conduct roving wiretaps. They allowed immigrants suspected of terrorism to be held for up to 7 days and sometimes indefinitely without being charged. These things may have criticized or may have increased, the security of citizens, but it reduced civil liberties. But when we're at threat, a lot of Americans think it's worthwhile. Somehow a reduction in freedom doesn't seem unreasonable for a reduction in fear. In the delicate balance between security and freedom, which side should we err? Obama stopped the practice of waterboarding, but Americans are more willing to tolerate reductions of freedoms when they come at the expense maybe of a non-U.S. citizen. The balancing of public safety with individual rights is complex. We could likely ensure more safety from threats if we gave up all freedoms. If the government could monitor all of our movements, they'd know who would endanger others. But without civil liberties, we'd have no protection from the government itself. How do we resolve conflicts about rights? This is often politics at its messiest, and there are many involved: the courts, Congress, the president, the people themselves. One of the jobs of the courts is to arbitrate disputes among things like rights. The Supreme Court is usually the judge of what is fair, but the rulings often change as the membership of the Supreme Court changes. They're humans too. The founders wanted them to be above the political fray, but they're still subject to lots of political pressure. The ideology of a president who appointed them, the influence of public opinion, the media. Sometimes Congress chooses to stay out of disputes about rights, and sometimes they take a decisive action to limit or expand rights. For example, the Smith Act in 1940 made it illegal to overthrow the government. Sometimes Congress protects rights, and the Civil Rights Act of 1991 broadened civil rights protections in the workplace. They held Don't Ask, Don't Tell hearings in 2010 on LGBT serving in the military, and the legislation was repealed that year. What about the president? He can be involved by lobbying the Supreme Court to encourage outcomes they favor. For example, in the 1950s, Eisenhower was reluctant to enforce desegregation in the South because he thought it was up to the states, not the federal government. JFK chose to be more actively involved, and he sent Congress a civil rights bill in 1963. What about the people? Americans sometimes use the courts to sue for what they perceive to be their rights, but they often act in groups. There are groups like the American Civil Liberties Union, the NAACP, the Sierra Club, AARP, NRA, things like this. They engage in fundraising and PR to publicize their views and work to influence government directly by meeting with lawmakers and testifying at congressional hearings. Their group efforts magnify a voice and can be considerably influential. What about the Bill of Rights? All right, so the Bill of Rights had a really stormy birth. There was a lot of controversy about whether a Bill of Rights was even necessary. It really deepened the split between the Federalists and the Anti-Federalists during our founding. Controversy didn't end once it was added as the first 10 amendments. Over a century passed before the Supreme Court agreed that at least some of the restrictions imposed on the national government should also be applied to the states. But why is it valuable? Federalists argue that the Constitution itself was a Bill of Rights and that individual rights were already protected by many state constitutions, and to add to the list of powers the national government did not have was dangerous. I mean, that implied that the government had every other power. This was spelled out by Hamilton in Federalist 84. Madison agreed at first, called it a nauseous project. But then he came to agree with the anti-federalists such as Thomas Jefferson, who wrote, "A Bill of Rights is what people are entitled to against every government on earth. A government limited in principle by popular sovereignty, which is the authority of the people. It couldn't hurt to limit the practice and specific lists of rights that would give the judiciary a better check. Some rights are protected in the Constitution itself, like habeas corpus, the right of a person accused to be brought before a judge and informed of the charges and evidence against him or her. Bills of attainder, laws where specific persons or groups are detained and sentenced without trial. This is forbidden. We're also forbidden to pass ex post facto laws, which are criminalized actions after they occur. Incorporation, of course, is when the Supreme Court formally incorporated the Bill of Rights to the states, but not all rights necessarily qualified for incorporation. The Supreme Court had to consider each right on a case-by-case basis to see how fundamental it was. Currently, almost all of our rights have been incorporated. Incorporation is a judicial creation, not a constitutional principle. So what the Supreme Court creates, it can also take away. Let's look at some of our actual freedoms, some of our rights. So freedom of religion. When is religious freedom valuable? When religion and politics mix, the stakes are high and passions are deep, and compromise is really difficult. The United States has been spared a lot of violence because of the First Amendment protections, but it's still not without controversy. It does establish general guidelines, which most people can agree on, and it says the courts are where you address your concerns. Perhaps a constitutional battleground, but they've kept the United States from becoming a literal battleground by deflecting religious conflict to the courts. The founders based their view of religious freedoms on two arguments. First, history has shown that linking church and state can have a negative impact on secular life. Second is the effect that politics can have on religious concerns. They worried that spiritual purity and sanctity of religion would be ruined if mixed with the worldly realm of politics that emphasized power and influence. So the Establishment Clause. This is the First Amendment guarantee that the government will not create and support an official state church. Madison and Jefferson were clear that church and state were to be separate, but after independence, all but two of the former colonies declared themselves Christian states. Non-Christian minorities were rarely tolerated or allowed to participate in politics at all. Jews couldn't hold office in Massachusetts until 1848. Separationists or supporters of a wall of separation between church and state. And then accommodationists are supporters of a government non-preferential accommodation of religion. They said that states shouldn't be separate from religion, but rather should accommodate it without showing preference for one religion over another. They argued that the First Amendment should not prevent prayer in school, posting religious documents such as the Ten Commandments, and things like that. Adherents claim that a rigid interpretation of separation of church and state amounts to an intolerance of their religious rights. A lot of Republicans share that view. So the Establishment Clause, the Lemon Test is a test that was established it was a three-pronged test. I took an entire class on this in law school, so sorry you're getting this so quickly. The Lemon Test is a three-pronged rule used by the courts to determine whether or not the Establishment Clause is violated. Lemon versus Kurtzman in 1971, the law must not foster an excessive government entanglement with religion. So that's how the courts got involved. What about the Free Exercise Clause? This is the First Amendment guarantee that citizens may freely engage in the religious activities of their choices. What about when religious beliefs against killing clashes with compulsory military service during war? When religious holy days are ignored by state legislation about the days on which an individual is expected to work? In the 1940s, the difference between a freedom to believe and a freedom to act on these beliefs, we can believe what we want, but a freedom to act is subject to government regulation. And then we have the police power, the ability of our government to protect its citizens and maintain social order. If a state needs to regulate behavior, it may. Compelling state interest, I talked about that earlier. It means a fundamental state purpose which must be shown before the law can limit some freedoms or treat some groups of people differently. It was rejected by the Supreme Court in 1990. where it held that the infringement on religion is not intentional, but rather the byproduct of general law prohibiting socially harmful conduct. Religious groups consider this a major blow to religious freedom because it places the burden of proof on the individual or the church to show that their religious practices shouldn't be punished, rather than on the state to show that interference with the religious practice is absolutely necessary. Congress responded in 1993 and passed the Religious Freedom Restoration Act. And there have been more concerns since then. Obviously, the Hobby Lobby case in 2012, there were concerns over religious freedom after Obamacare was passed. There were required employer-based health care insurance to provide birth control coverage. And the Hobby Lobby case said that corporations that are not publicly traded didn't have to provide this coverage if it violated the owner's religious beliefs, which affirmed some rights for corporations for individuals. All right, moving on to freedom of expression. Among the most cherished of American values is the right to free speech. But Congress makes laws abridging freedom of the expression. We tend to restrict speech that we don't like, admire, or respect. The challenge is to protect the speech that we despise. Why is freedom of expression valuable? In a democracy, citizens are responsible for participating in government decisions. But to participate wisely, they need to be informed. We need a watchdog check on government to keep government accountable, and there is a danger of setting a precedent of censorship. John Stuart Mills said, "Free traffic of all ideas, though known to be true as well as those suspected to be false, is essential in a society that values truth. We must allow expression of all ideas and discover truths believed previously to be false." But if the speech criticizes the government, this is sedition. This is speech that criticizes the government to promote rebellion. This has long been the target of restrictive legislation, though our founders were in the daily practice of criticizing their government when they were inciting revolution. They realized that this issue is on the other foot. They were far less willing to encourage dissent, and they felt the criticism of government undermined authority and destroyed patriotism. There were some early restrictions on speech. The Alien and Sedition Acts outlawed false, scandalous writing against the government. State governments in the South punished speech advocating the end of slavery. By World War I, freedom of speech and press were a sham for those who challenged the status quo. In 1971, Congress passed the Espionage Act, which made it a crime to engage in disloyal language about the government. The Supreme Court got involved and said that invoked the bad tendency test. This is the rule that the Supreme Court used that allows speech to be punished if it leads to punishable actions. So if what you're going to do leads to punishable actions, that's the bad tendency test. It's a pretty easy standard for prosecutors to meet, so most convictions here were upheld. The clear and present danger test is the rule used by courts that allow language to be regulated only if it presents an immediate and urgent danger. An imminent lawless action test is the rules used by the courts that restrict speech only if it's aimed at producing or is likely to produce imminent lawless action. This is what continues to be our standard for regulating political speech today. Symbolic speech, a lot of forms of expression go beyond writing. Should they be protected? When is an action a form of expression? Burning a draft card, wearing an armband to protest, torching the American flag. The Supreme Court is willing to allow regulation of symbolic speech, more of that than of speech alone, especially if the regulation is not a direct attempt to curtail the speech. Obscenity and pornography has probably presented the Supreme Court with the biggest headaches. In 1964, Justice Potter Stewart famously said that he could, about pornography, "I know it when I see it." There are a variety of tests to determine if something is obscene, but only until the 1970s, only hardcore pornography was regulated. There's something called the SLAPS test, whether the work lacks serious literary, artistic, political, or scientific value. Whether obscenity should be protected raises fundamental issues, including defining what is obscene, because one man's vulgarity is another man's lyrics. Fighting words and offensive speech. So fighting words is speech intended to incite violence. The Supreme Court has ruled that this can be regulated, but it rarely upholds the legislation designed to limit fighting words unless the law is written very carefully and specifically. It must produce a clear and present danger of serious substantive evil that rises far above public inconveniences, annoyance, or unrest. And then political correctness. This is the idea that language shapes behavior and therefore should be regulated to control its social effects. It really has swept the country in the 80s and 90s. After 9/11, there were some different, some conservatives treated any criticism of the United States as something close to treason. And then after 2016, there was a Republican primary narrative that liberals were overly sensitive and had stifled people's ability to express themselves. Freedom of the press, prior restraint. Prior restraint is the citizen censorship or punishment for the expression of ideas before the ideas are printed or spoken. It's more dangerous than censorship since the ideas never entered the public domain and their worth can never be debated. Libel is the written defamation of character. Slander is the verbal defamation of character. In New York Times versus Sullivan, the Supreme Court held that public officials, as opposed to private individuals when suing for libel, must show that a publication acted with actual malice, not just evil intent, but that it acted with knowledge that it was false or published with reckless disregard for whether it was false or not. This extended to public figures such as celebrities, political candidates, anyone whose actions put them in a public position. The Supreme Court said when an individual puts themselves in the public domain, the public's interest in the truth outweighs the protection of those individuals' privacy. We do have the right to a fair trial. Media coverage often leaves it difficult to find an impartial jury, but there is also a public right to know. The Sixth Amendment gives us the right to a speedy and public trial. Journalists often think this means proceedings should be open. Courts are reluctant to uphold gag orders that impose prior restraint on the press. There's a conflict between authors and creators of material who claim copyright of work, who want to stop access to their work without paying full fare for their use. And that's another sort of censorship on the internet. The right to bear arms, of course, this is a rallying point for those who want to engage in sporting activities, those activities involving guns, who believe firearms are necessary for self-defense, those who believe that an armed citizenry is necessary to check government that might become tyrannical, and those who don't believe it's the government's business to make decisions about who can own guns. There are various kinds of gun controls passed at state and local levels, but the NRA really has kept it to a minimum at the federal level. Why is the right to bear arms so valuable? The chief source of national stability in early America was the state militia system. There were armies of able-bodied men who could be counted on to assemble with their own guns to defend the country from external and internal threats. The Second Amendment was designed to guard against the tyranny of the federal government. There are arguments for and against the Second Amendment today. Arguments defending the Second Amendment today insist that the hunting and other leisure activities are important to American culture, and restricting any of them, even assault weapons, is to start down a slippery slope. The second is that possession of guns is necessary for self-defense, that gun control means that only criminals who would get the guns on the black market would be armed and life would be even more dangerous. Third is that citizens would have the right to arm themselves to protect their families and properties from a tyrannical government, should have the rights to arm themselves to protect their families and properties from a tyrannical government, just the way our revolutionaries did. And fourth, it is just not the government's business to regulate gun use. Some arguments against the right to bear arms, honestly, they've struggled to create a single compelling counter-narrative of their own. They argue that none of the rights of Americans, even fundamental ones like speech and press, is absolute. So why should the right to bear arms not carry exceptions? The irony of claiming the protection of the Constitution to weapons that could be used to overthrow the government is what the Constitution is protecting. Criminal defendants in this country have rights. We protect the accused from an arbitrary government. Half the amendments in the Bill of Rights are devoted to protecting the rights of people who are suspected or accused of committing a crime. There's concern for founders who feared an arbitrary government that could accuse and imprison people without evidence or just cause. A person is innocent until proven guilty, which comes from our English roots. You have the due process of law. This is the guarantee that laws will be fair and reasonable, and that citizens suspected of breaking the laws will be treated fairly. You have the protection against unreasonable searches and seizures. The founders were particularly sensitive because the King of England had the right to order the homes of his subjects to be searched without cause, looking for any evidence of criminal activity. The Supreme Court interprets the Fourth Amendment to mean that a person's home is private and cannot be invaded by the police without a warrant, which is only obtainable with good reason to think that criminal activity lies within. What's reasonable? There are few exceptions to search warrants. Automobiles are a special case, since by nature they are gone by the time an officer gets a warrant. They can be searched without a warrant if there's probable cause to think a law has been broken. This has been gradually included, the Supreme Court has gradually widened this to include luggage in the car. Wiretapping and surveillance is a little more difficult. Search was understood to legally require some physical trespass, and seizure was involved in taking some tangible object. The Patriot Act, of course, has made it easier to get some of these warrants. What about a cell phone? Do you have any expectation of privacy of what's on your cell phone? Because I have none. Part of the content of what is in your pocket what can be legally searched. In 2014, Supreme Court Chief Justice John Roberts said the average smartphone user has 33 apps that can form a revealing montage of the user's life. Phones are mini computers that contain the same amount of information about us that our houses traditionally contained. Just as houses can't be searched without a warrant, now neither can cell phones, but warrants aren't hard to come by, so people who store information on their cell phones should be cautious. What about random testing for drug and alcohol use, blood or urine tests? They say it's an unreasonable kind of search, but the Supreme Court allows them where a violation of privacy is outweighed by a good purpose, like discovering the cause of an accident, preventing drug use in schools, preserving public safety by requiring a random drug test of an airline pilot. In 2012, the Fourth Amendment was not violated by someone arrested for minor infraction and suspected of concealing drugs or weapons. They say they can still be subject to invasive strip search. What about the most controversial part of the Fourth Amendment, the exclusionary rule? This is a rule created by the Supreme Court that evidence seized illegally may not be used to obtain a conviction, even if police have concrete evidence of criminal activity. If it was obtained unlawfully, it can't be used. In England, it can be used, but the defendant can sue police. They try to deter misbehaving police by not allowing guilty people to go, but don't allow guilty people to go free. The American exclusionary rule can help criminals avoid punishment, though it deters police. They carved out a good faith exception whereby evidence is admitted to a criminal trial, even if it's obtained illegally, if the police are relying on a warrant that appears to be valid at the time or on a law that appears to be constitutional, though it may turn out to be defective, or a warrant obtained in error. The protection against self-incrimination, the Fifth Amendment, of course, provides for protections to individuals for not being a witness against yourself. This expands to grand jury, legislative investigations, police interrogations. 1966 Miranda versus Arizona, the police had to inform suspects of their rights to remain silent and have a lawyer during questioning. These are your Miranda rights. In 2000, Miranda was upheld as an established part of the culture. The Sixth Amendment, you have the right to counsel. You have the right to a lawyer to be present during police questioning. Right to counsel is now seen essential, but it's often violated maybe because of overworked public defenders or state laws that limit who can receive court-appointed counsel. The Eighth Amendment, the protection against cruel and unusual punishment. But what is cruel and what's unusual? The Supreme Court says not all unusual punishments are unconstitutional because all new punishments, maybe like electrocution, lethal injection, they're unusual when they first appear, but they may be more humane than an old punishment like hanging or shooting. They have not ruled that the death penalty itself is cruel or unusual, and a majority of states do have death penalty laws. In the right to privacy, this is the personal meets the political. It's not, the right to privacy is valuable because it's not really spelled out in the Bill of Rights, but it goes hand in hand with the founders' insistence on limited government. They wanted government to the government to keep from being too powerful and interfering with individual citizen life. It implied a right to privacy and assumed it, but it was not made explicit. Is it so obviously desirable that we should be left alone to do what we want that it scarcely needs a defense? The right to privacy without limits is an anarchy and the absence of government altogether, which is has an interest in preventing some types of behavior. Obviously, our government wants to prevent behavior like murder, theft, rape, but what about more subtle behaviors that don't directly affect the public safety but have serious consequences for the public good, like maybe prostitution, drug use, gambling, riding a motorcycle without a helmet? Should this be private behavior or should it be regulated by the state? The Supreme Court never really even talked about privacy until 1965, and whether such a right exists is still controversial. The Bill of Rights includes limitations and contradictions, but the right to privacy is the least certain of all. Reproductive rights. Until the Civil War, abortion bans were uncommon, Most states allowed abortions in the early stages of pregnancy, but opinion turned after war, and by 1910, every state but Kentucky made abortions illegal. In 1973, Roe versus Wade, the right to privacy did encompass the right to an abortion. They tried to balance a woman's right to privacy and reproduction with the state's interest in protecting human life. Congress failed to pass a constitutional amendment banning abortions, so they passed over 30 laws restricting access in various ways, such as limiting federal funding via Medicaid. It's become a really partisan issue. The Christian right make up a lot of the Republican Party. Republicans usually include a commitment to an abortion ban constitutional amendment on their presidential party platform, and they usually direct this to the states. Some other rights are gay rights. If there's a right to privacy, what should be held under it? The right to die. Is there a right to die protected under the right to privacy? Terry Schiavo, who was in a vegetative state for 15 years, had her husband said she didn't want to be kept alive by artificial measures and asked to have her feeding tube withdrawn, but her parents withdrew or challenged this decision. The court ordered the tube removed. It was a very controversial case. It prompted many Americans to consider getting a living will. Do individuals have the right to assistance in ending their lives when they're terminally ill and in severe pain? Should a patient decide? Would it violate a doctor's Hippocratic oath? In 1997, the Supreme Court said it should be left to the states. Citizenship and civil liberties. We've talked a lot about the Bill of Rights, but what about a Bill of Obligations? What would that look like? Obligations are the flip side of rights. For every right guaranteed, there's a corresponding duty to use it. Provisions for elected office imply a duty to vote. Congress is authorized to collect taxes. Citizens are obligated to pay those taxes. In Europe, such obligations are explicitly extended to include providing for the welfare of those who cannot take care of themselves. Tax burdens are higher, and sometimes the obligation to vote is legally enforced. How much fulfillment is enough? We obey laws most of the time. We don't pay all of our taxes. We pay most of them. If we don't vote, we do get involved in other ways. We're getting by as a nation for now, but maybe we should consider some of the long-term consequences to a democratic republic if the emphasis on preserving civil liberties is not balanced by a corresponding commitment to fulfilling political obligations. All right, sorry that was a little bit longer, guys. Thanks for hanging with me. I will be back with one more lecture this week on the struggle for equal rights. So we talked about liberties. Tomorrow we'll talk about, or later on we'll talk about rights. Hang with me, and I look forward to chatting with you again. We do have one more lecture before the exam on February 7th. Thanks.